So thank you, everyone. Thanks for joining us. I'm Milo, Sales Manager for Didasco and RTO Works. To all of our new guests, thank you for coming. To everyone that's been on our webinars over the last year, thank you for coming back and joining us again. This is the first complimentary free webinar of the year of 2026, and we are going to be running the complimentary webinars on a monthly basis. So please do have a look on the RTO Works website under webinars to see upcoming webinars and keep yourself up to date. Today, we are running a special webinar with a guest, Peter Doukas, joining us. Peter Doukas is the Managing Director of Dennis & Toyer, Australia's preeminent RTO legal practice. And we'll be talking about fit and proper person. Along with Peter, we have Sally and Scott, who you would all be familiar with. And if you are not familiar, Scott has recently joined us, not so much recently anymore. It's been over 6 months now, has joined us from Asqua, and he is a consulting, part of our consulting team, alongside Sally. Sally is our director and founder leading the consulting team. So this session today will run for 45 minutes. We will have a 15-minute Q&A at the end, so please feel free to stay on. But the session will finish at 45 minutes time, which is the official webinar coming to an end. We will also email across the certificate of attendance in the coming day, as well as the recording of today's session. So without further ado, I will hand over to Scott and we will go from there. Thanks, Scott.
Cheers, Milo. Thanks for that. Good morning, everyone, and welcome to the webinar. Happy New Year, and hope you're all having a fantastic 2026 so far. I'm pretty sure everyone is right back into the swing of things and preparing themselves for a busy year. So this morning, we're going to discuss the Fit and Proper Person Declaration and the requirements. And we're going to unpack what leaders in the vet industry need to know and ask some very thought-provoking questions. So as Milo mentioned, to help me do this, I'll be joined today by Sally Tansley, the founding force of our company, and also the head of the consulting team, and as well as legal expert Peter Doukas. So welcome, Peter.
Good to be with you. Hi, everyone.
Cheers. And how are you going, Sally?
Yeah, good. Hello, everyone. Thanks for coming. Hope you're all having a good year so far and wish you a good year ahead.
Yeah, fantastic. And as also, I know Milo's introduced me, but for those who don't know me, I'm Scott Templeton and I'm one of the compliance consultants there at RTO Works and also former Asqua auditor. Okay, got plenty more people joining in, so that's good. So to set the scene for this morning's discussion, from the 1st of December 2025, Asqua released a new version of the Fit and Proper Person Declaration, which includes several amendments. So this form is now in effect, and providers have an obligation to ensure that all staff involved in vet delivery meet the Fit and Proper Person requirements. So as we know, the Fit and Proper Person Declaration must be completed by all governing persons as defined under the instrument. And this includes the executive officer of the RTO, high managerial agents of the RTO, and any person responsible for overseeing, directing, or exercising a degree of control or influence over the management and operation of the RTO. It is also noted on the Asqua website that providers may be asked by Asqua to provide a declaration for any individual at any given time. We'll discuss this throughout the webinar, and we'll also talk about who must complete this form. Okay, to get started, Peter, would you like to give a bit of a brief background on yourself and your involvement in the vet sector?
Thanks, Scott. My involvement in the vet sector is purely by accident. I have been working in the sector for about 15 years through my legal practice in Sydney. And in that time, I've done some of the largest cases that have come before the tribunals and courts. Yeah. And it's been a very interesting journey, and it continues to be an interesting journey. But primarily, my work is as a regulatory lawyer within the vet sector.
Okay, yeah, wow, that's very interesting and very important work. Okay, so we've got the first question to kick off here, and I believe we'll be sharing a document now as well, which is actually the fit and proper declaration, which will come up on screen shortly for everyone to see. So, Peter, what is the fit and proper person declaration, and what are the FPP requirements? That is often a term heard in audits.
Yeah, thanks, Scott. Well, the declaration itself is a document that is completed by anyone wanting to exercise managerial control over an RTO. And it's changed a little bit, but the FPP requirements that we talk about are those regulations that are set by ASQA as to who fills it in. So it's a document that must be completed by, for example, the CEO or other high managerial agents of a provider. There is a broader definition, and you'll see it on your screen, about who must fill in a declaration, and we'll talk about it a little bit later. But broadly speaking, a fit and proper person declaration is a document that is completed by any person exercising managerial control over an RTO. And it is a statutory declaration, so it's like a stat dec that we would talk about, and for that purpose, it is a statement as to truth that must be submitted to the regulator in certain circumstances, and they are used by ASQA to police who runs RTOs, how RTOs are run, and whether those people are of good character.
Yep, fantastic. No, that's very good. Okay, so it's understandable that given the complexity of the form and some of the language used, the forms can often be misinterpreted and therefore seen as completed incorrectly. What are some of the common mistakes and misinterpretations that people make?
Look, Scott, I rarely see forms completed correctly.
Okay.
They're complicated documents, and they're complicated documents because, as you'll see on your screen, they are not just a simple declaration. I worked here, there. They are documents that talk about the interaction of the person that's filling it in, because this is a personal declaration to the rest of the vet sector, other RTOs, other non-educational institutions, as well as their general character. So, for example, criminal record, financial record, bankruptcy, etc. So these are complicated things that interact. And we always talk about the reason that the correct or not correct. Generally speaking, if you're truthful, if you try to be truthful, and if you make an error, ASQA's okay with it. But it's that deliberate misleading, which is not only illegal, but that's what they're looking out for. And I'll go into little bit of detail further. I'm sure you've got some questions about sort of the nitty-gritty of these forms. But generally speaking, it is because it's ASQA's tool for assessing the people working in their sector. It's a really important document for them and for and broadly for the industry.
Yeah. Okay, definitely. Is there a comeback from fit and proper declaration that has been completed incorrectly? Like, are these forms, I guess, rectifiable per se, or are they able to be resubmitted if the regulator has identified issues or missing information? So say if they've said, you have noted that you don't have a relationship with another RTO, but we can see that you were previously this RTO. So if it was, an honest mistake or something like that, is there any comeback per se from this?
Yeah, look, it depends on the level of the error. There is a comeback. The answer to the question is absolutely there is. And that could either occur within the context of the review being conducted by ASQA, or if there is an external appeal, such as to the Administrative Review Tribunal, for example. So they are rectifiable, but because they're declarations, ASQA is very interested to know why that error was made. If it's a simple error, like I had one where someone got their gender wrong. It was just, they just ticked the wrong box, for example.
Yeah.
It was and I mean, that's obvious errors. There was never an issue. But there are others where there is a deliberate, I've had other examples where there has been a deliberate misleading of the regulator in terms of the interests that somebody has held or the control that they've had over a provider. Now there are, I say, there's scale of kind of incorrectness, if you want to call it that. There's a scale about what you can get wrong, what you don't get wrong. But overall, the the regulator, when they identify issues, some of the times, depending on the auditor, they will identify those issues to the person submitting the forms and invite a resubmission, for argument's sake.
Yeah.
Or if there's pages missing or things like that. Some of the areas where I have concern about is these expanded regulations regarding fit and proper person declarations that want non-high people that are, in my opinion, not high managerial agents, like
Right.
people that are not
Yeah.
directors of the company or not the CEOs, people not involved in intricate management of the company, who also have to request the fidelity, like consultants, and I've had these arguments with ASCO, like lawyers. And that's where we have these philosophical differences about who should be filling them in the first place.
Okay. Right. Thanks for that. When you it has been identified that there was an issue with your form and you are going to resubmit, would it pay to include a statutory declaration as like an additional appendix when responding, just stating that yes, this form has been submitted in error due to a misinterpretation of a question, and therefore I wish to submit this new form? Or do you think that the actual resubmission of the fit and proper is probably okay?
It depends on the error.
Yeah.
It depends on the error. So a couple of years, nearly 10 years ago now, I had a
Yeah.
so this was an earlier version of the fit and proper person declaration. My client had obtained independent legal advice about previous relationships. By the way, this is a university professor, highest level of integrity, highest level of educational standing, currently employed. At that time, he was currently employed at one of the G8 universities. So this is a serious educator.
Right.
And he didn't disclose some association that he had with a higher education entity and an RTO previously, which had, subsequent to his involvement, been shut down. But it was a breach. So this was acting on advice. So the solution was something of what you've indicated in your question, that a subsequent declaration that I acted on independent legal advice, and this is what I did. And then eventually, it took a while for us to get over the line with ASQA on that point, which I thought was an error on ASQA's part. But
Right.
Eventually they come to where it's a simple, silly error. I missed page 5 of the document. You can resubmit it. In my view, you resubmit a new declaration. Where it's an obvious, simple error, where you've had a change of address, for example, where you've had, and then let ASQA ask for the further material, because a statutory declaration is a powerful document, and it's a nuisance to go and get them done. So you don't want to keep redoing them or offering stat decks unless you absolutely have to. So as a general rule, if it's use the pub test. If it's a dumb error, if it's a simple error, just redo the document. If it's something that is significant, and particularly if it's been brought up by ASQA, then there is a degree of correction that needs to be done.
Okay. All right. Well, thanks for that. How long do criminal convictions or traffic offences such as that last against your record? Is it only offences that are related to, say, business, fraud, or like violent crimes, for example, that are considered to be a red flag, or is it literally anything?
It's literally anything, but of course within a sliding scale.
Yep.
So, let's unpack what a criminal conviction is first. So, a criminal conviction is a ruling from a court that a defendant is convicted, and that conviction and the criminal record lasts, depending on the jurisdiction, depending on which state you're in, or whether it's a Commonwealth jurisdiction, or the seriousness of the offence that has been committed. It generally lasts between 7 to 10 years. And then there is a principle of a spent conviction. So if, for example, you had a drink driving offence 20 years ago and you applied for a job somewhere, you no longer have a criminal record. You do have a record of a past criminal activity, but it's no longer an active criminal record, if you can call it that. The word active is my word. It's not an official term, but if you can call this principle that, there is an idea that a criminal conviction can become spent. You don't get those luxuries when you are applying for the role of management of an RTO. Because you are held to a higher standard. So ASQA is, in my view, entitled to know about your whole history. Now, in some circumstances, so So that's when we talk about criminal convictions. So all criminal convictions, and they say including spent convictions. I particularly remember one of the earlier versions of the declaration when they introduced that spent conviction, which I think is still in there now. That is specific to convictions that were ages ago. They just want to know, right? Now, there are some regulations around ASQA making a decision about someone's fit and proper status as a result of spent convictions. But now let's zoom in. When we talk about someone's record, whether it's a criminal record or any records, at the bottom level, ASQA asks for driving offences. They used to ask for all driving offences, but driving offences that are unrelated to the vet sector, broadly speaking, are not relevant in the fit and proper person declaration. What is relevant is the declaration itself, the honest declaration. But let's assume we get an honest declaration. So driving offences, and broadly speaking, if offences that are not related to the provider that is intended to be operated by this person, I just accepted and moved on. I've had people with criminal convictions, with serious criminal convictions, disclose them. ASQA notes those convictions, and the matter proceeds. So it's irrelevant. If it's unrelated. However, if you've got somebody that's on a sex offender register, the chances of that person being found fit and proper, particularly for the management of a childcare college, is very low. Similarly to someone with serious drink driving offences for a driving college. Fraud convictions, and I've seen this in practice, and I've actually acted in criminal matters where ASQA has brought charges against the person, not necessarily for the fit and proper person declaration, but they leveraged that person's declaration. My guy had a fraud conviction, and they were trying to get involved in areas that in courses or teach courses that required trust accounting.
Right. Okay.
So, as a general rule, and particularly recently, in terms of those the element of criminal convictions, I think ASQA's got good advice. They're sensitive to the things that they should be sensitive to. As long as the declaration is done correctly, they're not overly sensitive to things that are not relevant.
Right. And that's that sliding scale you're talking about. So that really makes sense.
They don't always get it right though. But we were talking about this a couple of days ago, Scott. I had a client many years ago who had been an officer in the Australian Army, like a senior officer in the Australian Army, ended up in Washington on some military exchange, having been vetted and approved by the CIA. So he was some kind of intelligence, senior army officer in intelligence in Washington, came back to Australia after his military career finished, wanted to set up an RTO, and completed all the forms, and everything was perfect. This guy was a seasoned educator, another PhD, seasoned educator, got rejected with an allegation of fraud from ASQA because he had not completed the fit and proper person declaration correctly. And the allegation was that he had a conviction that he had never disclosed. Now, this conviction was in the 1980s. He had committed a driving offence and then was tried in his absence in some court in Western Australia, fined $60, but convicted. Now, our Australian Army didn't care. He didn't even know about it. The CIA reviewed his file, didn't know about it, didn't work it out, and it only came to ASQA's desk where it actually was picked up, and it was the first time he ever heard about it.
Wow.
In fairness, the error there was the non-disclosure, not the irrelevant driving offence. But this is why we need to be careful of the way that records are dealt with. I think the new declaration is sensible, that it doesn't ask for silly things like parking tickets and things like that. Because someone like me would have like a 500-page fit and proper person declaration if we did. And I think, if I had my way, and by the way, ASQA's not kind of forced in this. This is an ASQA decision about how these things are structured. It could notch even one step towards the more reasonable thing. I mean, I don't think ASQA needs to care about driving offences, particularly, and even low-range drink driving offences. It's not relevant to anyone. No one really cares about that kind of stuff. What I'm interested in is
Mhm.
is bankruptcy. What I'm interested in is serious criminal law or
Yep.
criminality. You know,
Yep.
but that's a completely different conversation. So that's
Yeah.
where,
Okay.
and I've made submissions to ASQA about where do you draw that line, and I think they would save themselves a lot of time and resources
Yeah.
policing this stuff. So
No, fantastic. That's
Could
quite
could
insightful.
I ask a
Mhm.
super quick related question there,
Of course.
Peter? With the fit, the instances that you're talking about, would they have set criteria, or would every instance be discussed with a legal team, for example, within ASQA?
well, that's one of the great mysteries of the internal operations of ASQA. Look, I people often ask me, is there a conspiracy or is it just, public servants in a room trying to work it? I don't think it's anything like that. I think it would go, if it was something serious, it would go to the legal team.
Mm-hmm.
So, for example, my matter, which was a fraud matter, where there was allegations of, a non-disclosure in the fit and proper person declaration. So the guy had, so my person had a serious fraud conviction from years ago, where they'd served jail time, and then there was a subsequent non-disclosure. That obviously has gone to the legal team. But the other examples, I don't think that ASQA's lawyers have the time or the inclination to be sifting through, someone's drink driving records or anything else. This is about. I'm sure, Sally, they probably have a trigger warning at some point. If someone's got serious convictions or someone's got active convictions or there's other things
Yeah.
that are relevant that gets referred up the chain. But as a general rule, I don't. I just think that they apply, at least in my recent experience, a relatively sensible approach to criminal convictions. I do think, though, Sally, that that ASQA was just shooting themselves and everybody in the foot in the way that they look at the relationship of people that fill out fit and proper person declarations to other RTOs, particularly other RTOs that have been sanctioned. And I think a lot of damage is being done to vocational professionals who are professional educators in middle management within the RTO space, who are completing fit and proper person declarations, but are always coming to me terrified of losing their fit and proper person status because the college that they used to work in is getting shut down, or their college is getting shut down. So when decisions are being made completely outside of their control, good people are being punished from a fit and proper person perspective.
Yeah, that's right, Peter. So there can be issues that can arise with people's associations with an RTO from the past that actually now has a bad compliance history,
Yep.
or they may have been cancelled. So is there much of a run-on effect of that, or is it just a case-by-case thing? And I guess as long as you're truthful and completing the form to the best of your knowledge, I guess if ASPA wanted to take it further, you'd have to have that discussion with them then and say, look, I was a trainer and assessor there. I wasn't involved in any management decisions. The college is different to when I worked there. I have nothing to do with the way that they operate now. I assume it'd be a similar sort of scenario as that.
It is, but I have not seen good things so far.
Right.
No,
Okay.
because they have so it's like what I say, and I think Paul asked a similar question about can someone access fit and proper person declarations that have been submitted on my behalf as well. Remember, a declaration is submitted by the RTO normally through ASQUIN, and unless it's emailed through some kind of independent audit structure.
Yeah.
So, by the way, I know ASQA has a new word for audits, but I am old school and I will always refer them as audits. So
Yeah. 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 Yeah.
I don't care what the marketing people say. I will always
Yeah.
refer them as audits, and you can come after me later.
Yeah.
The principle, though, with these when you're within a review or the context of an audit, is that the RTO has that interaction with its regulator. And I think this is one of the areas where I'm hopeful that the new ASQUINet, whenever it actually starts working normally and properly, allows individuals within the sector to access their own records, to
Yeah.
access the documents that have been submitted on their behalf. I hope, because I think, and it is this principle of what we call natural justice that if I'm working in college A, I'd really want to know what they're submitting on my behalf.
Yeah.
Particularly if ASQA wants to expand the requirements for fit and proper status, or someone to be fit and proper, to middle management and management that does not have decision-making capacity, people that don't have decision-making capacity, then I'd like to know what's been submitted on my behalf, particularly when you're talking about stat decks. And we've seen, as we've seen in recent years, unfortunately, fake documents circulating, not only about students, but also about trainers.
Yep, absolutely. Yeah, okay, Sally, this is a question for you. Who should be completing the fit and proper declaration forms? I know we've discussed a little bit already, that under this new fit and proper, the new amendments that have been made, there are more people that may be asked to fill out the form. But do all staff need to? And as consultants, for example, are we required to?
Yeah, so I mean, if you look at the form, it still talks about, governing persons, and essentially they are people who, make decisions.
Yeah.
A trainer and assessor wouldn't be required to complete that form unless they were also, say an RTO manager. But yes, certainly on the new form, they talk about consultants and education agents, and I'm already seeing, some issues there. So for example, there are clients who used to own an agency but don't anymore. And as strictly speaking, the form requires that they disclose that. And one of the issues which Peter and I have chatted about as well is if as a consultant or an agent, you have to, if you're required to complete that form, then that would require you to share some, extremely sensitive information, i.e., you'll be talking about all the clients that you'd been involved with, and which sort of, as Peter pointed out, contradicts privacy law. So,
yeah, it's like client confidentiality. Yeah,
exactly. Yeah. So, there's some real issues. I mean, we personally haven't been asked to complete one, have we, Scott?
No.
Yet, and I would hope that it remains the case.
Yeah. Okay. It's understood that related persons do not usually complete a fit and proper declaration as relevant information. But it is requested in this declaration. So governing persons, high managerial agents, executive officers, and people of influence, the form actually lists several examples of each of these titles, and some of which were not highlighted in previous iterations of the declaration. I think a lot of people would have a question around an agent who recruits on behalf of your RTO. So, Peter, would this mean for RTOs who possibly have hundreds of agents engaged, it'd be quite a task to actually obtain all these declarations from all? Is it necessary? So if an agent has 10, 15 staff members working at that agency, would that technically mean that all of those staff members would need to submit a declaration, or is it only people who are actively involved in recruiting? I know that's a bit of a tricky question, but
well, and I want to go back on what Sally said too, but I'll come to that in a moment. Yes, I mean, if you look at it, if you apply a black letter law approach, the answer is very broad, and you need to fill it, and everybody needs to fill it in, which is just silly. Because where do you draw the line? I mean, how do you? At what point can you draw the legal line? And I've been in audits and I've had discussions with their senior lawyers about these issues, because in the example of an agency, most of their staff are contractors or subcontractors.
yeah,
That then creates an array, a web of subcontractors, which are separate entities sometimes, separate companies. So if I've got RTO A engaging company B, which engages subcontractor C, D, E, F, everybody there needs to be filling in declarations. It creates an impossible arrangement for the college, an impossible compliance situation for ASQA. I have been asked to fill out a fit and proper person declaration. In fairness, I have been involved in the highest level decision making in very large companies who are also RTOs. So multi-billion-dollar organizations who happen to be also an RTO somewhere in their big web. And I have been involved at the board level of those discussions and decisions for the purposes of providing legal advice. And I've had ASQA auditors and this it was worse in the past, but it still sometimes happens. Question me, say, well, you're sitting there, you're a company secretary, or you're the engaged legal counsel. You are there in every decision that they make. And I said, yep, and it's legally privileged. And the principle of legal privilege extends to Queen Elizabeth I. So if you want to overturn 400 years of common law tradition with your ASQA fit and proper person declaration, go right ahead, but you'll fail it in every court. Because as lawyers, we are protected. And I also can't fill in the form honestly because I'm legally prevented from disclosing the companies that I've worked for. Not that I'd even be able to give a list because I wouldn't remember everybody, right? But theoretically, as an advisor, I mean, I spend my every day talking to RTO people, whether it's an owner, whether it's a manager, whether it's a staff member or a lawyer. They're my days. So how would I possibly remember every single organization that has made a decision based on my advice? And that's if you really read into the declarations, that's the stuff that's necessary. Separately, consultants. We haven't seen it yet come to the tribunals and the courts but they have the power to mandate it. So, Sally, in one of your arrangements, you could actually be forced in an audit to say, well, they could say to you, you must fill this in because you're involved in the decision making of the college for any reason, which is again the same principle because as professionals we have obligations of confidentiality. People engage us to do work, and they don't want the mere fact that we've been engaged. No, that's something that's private to people. And Jenny just asked, would an accountant be required to do so? The answer to the question is the same. It is equally the accountant is equally conflicted in that scenario. So you've got the accountant's regulations versus ASQA's fit and proper person declaration. And I think ASQA's been turning a blind eye, which I think they need to in the circumstances, because it's just an unnecessary fight. It's an unnecessary question. Who cares what other RTOs the accountant has worked for example?
And also, Peter, I wouldn't actually see that, for example, you, me, the accountant, Scott, etc., are actually, making decisions. We're simply providing advice.
Correct. And that is the most important point. And when we talk about agents, when we broadening the web, if you want to call it the web, of people caught up in fit and proper person declarations, the people that benefit from this are the dodgiest operators in the market because they never cared in the first place. And no matter what you do, they're going to lie. And no matter what happens, they have their own complicated structures that are completely immune to proper regulation.
Yeah.
So all that's happened, and I've made formal representations to ASQA on these questions. All that's happened by this broadening of the fit and proper person regime is the cost of good compliance has increased, and I guess you could call it the collateral damage to the non-owners in the sector has expanded. And people, in my view, people are leaving the sector because of this, because they're under personal strain. And by the way, if you're found unfit because of a fit and proper person issue, that's by a Commonwealth agency that then is disclosable elsewhere to the Commonwealth for other interactions within the Commonwealth. And we're not even talking yet about funding bodies like the state funding bodies, because that's a whole different conversation. So that's why I think governing persons, the list of governing persons, we apply the good advice of organisations, of consultants like Sally to kind of work out where that balance is, and you've got to strike that balance.
Yeah, that leads me into another question there, Peter. So once you are deemed not fit and proper by ASQA, is there any case for rebuttal, or are you considered not fit and proper for life, or is there a time frame surrounding this? So, say for example, you were deemed not fit and proper, you'd had a recent bankruptcy, or say, for example, if you were declared bankrupt, that's for a certain amount of time. Is there a record of when you would be free from this, and you could be able to apply again to see if you are now fit and proper. And also, what is the impact with other, federal agencies once you're fit and proper? So is it just ASQA that you're not fit and proper with, or would you be considered not fit and proper with a whole bunch of other federal agencies?
Let's start with the last question, and then we'll
Yeah,
go to the first one.
sure.
ASQA, the other agencies have to come to their own conclusion, right? But
Yeah,
you must disclose it, and it becomes relevant to the other agency's determination,
yeah.
right? Which is why it's so important.
Mm-hmm.
Now, if so I have been an advocate, and and again, it's one of these things that I've made representations to ASQA in writing, and I'm talking to them and annoying them about this issue for a very long time, that there should be a list of people deemed not fit and proper, and that list should be public, and somebody could be found. Like let's say that I was running a dodgy RTO and I got found and it was cancelled. They could make a ruling. That decision could then be, if the person decided, appealed.
Yeah.
If the person decided, it could be appealed, and that would
Yeah.
be a public hearing about this, about whether somebody is fit and proper. And unless you're on this public list, you're automatically deemed fit and proper.
Yeah.
ASQA does have a list. I've had this confirmed. ASQA does have a list of people that they don't like, or that are not fit and proper, as they should, because there are bad operators who we've seen. But that list is not public, and they do make fit and proper findings, but those decisions are not appellable in the way that we appeal decisions to the tribunal. For example, let's say you get a sanction and you want to appeal the decision,
Right.
automatically appellable.
Yeah.
There are other appeal mechanisms for a finding of fit and proper person status. However, in my view, they exist primarily within the judicial review powers of the federal court, which is huge and unnecessary. So to give you a this is as it currently stands, right? So this is, again, by the way, this is not formal legal advice to everyone. I'm just giving you my
just a discussion.
But so the federal government just came out with a law about anti-racism, and the Minister for Home Affairs has the power to deem an organization as a hate group. And the only way that group, if let's say there was a group that was deemed as a hate group, they would have to appeal to the federal court to make a determination as to whether they had the right to not be classified as a hate group.
Okay. Yep.
The appeal rights for someone deemed unfit by ASQA is the same. It's at that level, and I think that's a mistake.
Right.
We don't have proper appeal rights, because if we did, no, the dodgy people would never appeal.
Yeah.
But if it was a public record that you could actually see, and there was a public process where this could be determined, if somebody wanted to fight it, let them fight it. Let's have it out. Let's have it as a public hearing about it. But otherwise, these are the concerns. So yes, you can challenge it. Primarily when we make findings of fit and proper person, when we challenge fit and proper person findings, they're within the context of an RTO. Where they're within the context, for example, if the RTO is cancelled and the owner or the CEO, we consider that person as an unfit person. And let's say that owner, let's say Bob Smith, who's the CEO of dodgy RTO number one, in a year's time tries to register a new RTO, the way that fit and proper person fight has been had is in fighting over the appeal of the new RTO.
Yep. Okay.
Whether it's been cancelled or not. And to close off, in the tribunal matters that I do, as a general rule, and ASQA, by the way, is okay with this too. I often, when we appeal a case to the tribunal, 90% of them are settled between the party and ASQA without the need to go to a final hearing.
Right.
And we do terms of settlement, almost like a contract, which gets submitted to the tribunal, and then that becomes an order of the tribunal overturning the decision. And that is it's not always antagonistic. The ASQA lawyers are actually pretty good to deal with. I have a lot of good relationships with them. We work together quite often. But as a general rule, when we submit orders to the tribunal, I often put in a provision of good faith. So parties are entering into these terms in good faith. And sometimes, if I can get away with it, that the regulator considers that the conduct of the RTO has been fit and proper, or has been appropriate within the standards of its fit and proper person requirements. Things like that. If you can get that, if you can sneak something like that into an order of the tribunal, it's really good. Because then you've basically got an external clean slate.
Okay.
But that's the unfortunate thing, because this fit and proper regime is it's not a science. It's much more of an art, because you've got So they're the concerns that I've got around it. But overall, though, there is a real fork behind it.
Yeah, that's right. And as you did say earlier on, it is unfortunate that sometimes it's the bad faith providers that actually are the ones who aren't having these issues, because they wouldn't be submitting the fit and propers and they wouldn't be therefore having these issues. But people who are out there, the good faith providers want to do the right thing. They want to submit all of their applications. Then there's sometimes other people who are questioned. But at the end of the day, look, it all comes down to, acting in good faith, being truthful, and doing the right thing, and submitting, the fit and propers for all the relevant people. Just with these new amendments, one of the big takeaways for me was just like knowing and understanding that, all the third parties that are involved. So like, your consultants, education agents and so forth. And there's even a line that was in the form, something to the effect of, was to do with third parties or people employed by third party organisations who fulfil any roles described by the RTO. So for me, I was thinking, well, it really does lead to it that it's going to be, potentially hundreds of people that you would be sending in these forms for. But I guess what you really need to be doing is ensuring that all your agents and people involved, they are at the ready to be able to complete these forms if necessary and if required, because as it says, ASQA can ask a fit and proper from any person, then understanding that that's what you would have to do.
So yes. And the strange thing is, no Commonwealth agency can force you to sign a statutory declaration.
Right.
You have a legal constitutional right. You can't be forced to sign a document.
Yeah.
So what they do is they say, we will, this is a requirement in order to pass an audit. Yeah. They won't say that Peter must sign this.
Yeah.
So that's the first issue with it, right? Yeah. So I want less and better versions of these documents. Yeah. Number two, third parties have to fill in, you have to submit third party agreements.
Yeah.
So why do you need to overlap third party agreements with proper person requirement? You can have, I would love agents to have their own register. I'd love agents to be regulated just like RTOs are, because the poor RTO is subject to all these regulations, and the agents have basically run amok because of being subject to because they haven't been subject to regulations. So this is why when I started at the beginning, I said that it's impossible to get it correct.
Yeah.
Impossible to be perfect. And I think this sliding scale, CEO, director, must be as close to perfect as possible. CEOs and directors. A question was asked earlier about silent owners and silent partners of RTOs. Which is, so the rule used to be, I think, 15% or something. Anybody that owns 15% or less. So I didn't need to fill it in, which is correct. I think it in practice, it doesn't matter to me who the owners of an RTO are. It doesn't matter, and the idea of ASQA using them as using fit and proper person declaration as data collection is unnecessary. We have ASIC for that purpose. We have a CEO and a director for that purpose. In my view, if I had my way, I would send every RTO CEO to do some kind of course about RTO management and have it as a mandatory thing. So that you can't have these shadow people who don't know what they're doing running RTOs. You have people that are properly paid, properly resourced, running these organizations. And we did it in Australia. We've done this reform in Australia with publicly listed companies. You never see these issues happening with public companies, and they don't have a fit and proper person regime. But it is, in my view, really silly that the Vice Chancellor of Sydney Uni can have a criminal conviction and not need to go through the fit and proper, without a problem. And the CEO of an RTO does have a problem. I
Yeah.
find that that's a problem. Not that I don't even know the vice chancellor of Sydney Uni, but the text and
Yeah.
regulations
Yeah.
are completely
Yeah.
different.
Yeah.
And that is the I think the imbalance in our sector that it's not only a question of advocacy, but about
Yeah.
good regulation. So I
Yeah.
think ASQA's doing okay.
And
I think
that's
they're really trying. I think they're really
Yeah.
trying really
Oh,
well.
absolutely. Yeah. And it's important that people in the industry and we have these discussions and ask the questions. Because at the end of the day, we all want to do the right thing and
Yep.
we all want to, get on and thrive in our business. So definitely very insightful conversation there, Peter. We've got a bunch of questions now. So we have a bit of a designated question time for the last 15 minutes here. I know we've gone a little bit over, but that's great. So
We can talk
I
about
think
this all
there's been
day.
Yeah.
there's a bunch of questions that have been submitted through in the side chat there. So we'll try and answer a few of them now and go through them.
I
I'm just
noted them down. Did you want me to go through them
Yeah,
all?
so just any questions you think are ones we should definitely address and have a chat about, Sally. Just yeah,
Yeah.
let's go for it.
So the first question that came from Bipin was he had major concerns for Section D related person and Section F RTO and provider history. So I think that's with the related persons issues, worried about that. Like, so say, I think what
Like a
Bipin,
spouse or something.
yeah, that's it. Yeah,
Oh, it's so dumb, honestly.
yeah.
Sorry, I mean it's so dumb, and I've said it before. It's so dumb. What possible use does Asqua get by knowing what my wife does or what my wife's
Yeah,
history is,
yeah,
right?
yeah,
Like, and in fairness, what possible capacity do I have to inspect what my wife has shares in?
mm,
Right?
yeah,
Like that's all we're talking about now, right? And you're right. It is now, and I've had these arguments with Asqua during audit during in an audit setting, and subsequently in tribunal and court settings, where they're saying, "Oh, you didn't adequately disclose that your partner was or your spouse was a shareholder in or a CEO in RTO XYZ."
yeah,
All right. That involves things that are impossible in terms of knowledge.
yeah,
Ultimately, when I say impossible, you could eventually get there, right? But it's not actually fair to ask someone about the management of an entity. So let's say there is another company. Let's say my wife is the CEO of an RTO, and
hmm
at the point in time that I'm signing my fit and proper person declaration, my wife has resigned, but is still on Asquinet. How can
yeah,
I know that?
yeah,
How can I know when the notification of that resignation has been put in? Now, there are declarations about whether that person was ever or is currently, right? So
yeah,
these are the things that I think are just, it's an unnecessary use of resources,
yeah,
right?
yeah.
Yeah.
We've got a question. This was from Michelle Currow saying, the way the form reads, a trainer assessor would not need to complete the FPP. However, Saxon Rice's email in April 2024 made it appear that the trainers and assessors would be considered as they exercise a degree of control or influence. So this really, and I have seen this in the past, it is a very case by case scenario. So more often than not, the trainer and assessor, you wouldn't be asked to complete a fit and proper declaration. The only cases where I've seen it is when there has been a relatively small RTO with a really niche scope. And say, for example, you did the HLT qualifications only, and the people who were in management positions of the RTO, so the CEO, high managerial agents, they had no history or background within first aid or doing CPR and things like that. Whereas the trainer who they had hired really was the main person in the organization who was going to be responsible for how, they met compliance with these qualifications. That's how it was explained. So therefore, as the trainer and assessor is technically the expert in this niche field in which the RTO is, like it's essentially where a first aid RTO and the only person who really knows much about the field of first aid is this trainer assessor. That's when the trainer and assessor has been asked for a fit and proper because they were considered, look, you're the one who's going to be deeming these students compliant. You're the one who's going to be really ensuring that we're compliant, with the delivery and the assessment evidence. So that person has been asked for a fit and proper. And I have seen that in the past. But it has only been where it's been quite a niche RTO and the trainer and assessor were seen as someone who is influential as to whether they're going to meet compliance or not. It's rare. I haven't seen it that often, but I have definitely it has occurred.
Scott, it's interesting. You're absolutely right. I've seen that too.
Yeah.
Basically, yeah. If the trainer has a higher role than just training and assessment,
Yeah.
then absolutely. But on the other end of the spectrum, I've seen about 2018, 2019, ASQA came down really hard on non-lodgement of event vis data.
Yeah.
And a lot, like 300 RTOs were cancelled, of which were some really big household name companies that had happened to have an RTO. And so I had this company, which will remain nameless, that has a serious board, right? So a board of and they're not in the education business. They just happen to have an RTO and an education subsidiary to train their own people and to train some external people that they were contracting with. And every director on the main company was a director in all their other companies. So they had 100 companies, they had 5 or 6 directors, and every single director was the director of every company. So basically, we've got an RTO with 5 directors.
Yeah.
Only the CEO had filled in the declaration.
Yeah.
Now, this company had been allowed to get through re-reg and re-reg and re-reg. No one cared. No one asked the question. And it only came up when they came to me after having been cancelled to say, oh, guys, shit, we've got a problem now. We've got multi-billion-dollar Commonwealth contracts.
Yeah.
And our really serious directors are now going to be found not fit and proper for effectively defrauding ASQA by not filling in fit and proper person declarations when they were directors of the company.
Yeah.
Right? It's unbelievable that ASQA didn't pick this up.
Yeah.
So that's the other end of the spectrum, right? Now, obviously we got them through. There was never an issue. It was you would have read about it in the paper if it was a big problem. But, but the moral of the story is that it is a lot more of an art than a science. ASQA has they do it on a case-by-case basis. They assess it, and you've got to have your argument ready. Which is why I think business planning is not just the thing that you do as part of your financial viability risk assessment. It is core to the RTO. You need to have. I've been really successful in the past with big RTOs where we had board meetings and we had there were archive boxes back then, but paper. But we had 15 years, or we have 14 years of board meetings. So some of my time and some from my predecessor.
Yeah.
Every single decision that was made was documented.
Yeah.
And when ASQA ever asked, we could say, here you go. Here's our archive boxes of board minutes. Go get those. Right?
Yeah.
Having that is kind of a description of the soul of the organization.
Yeah.
And that's how we talk about, and then you can justify a decision that your senior trainers don't need to do fit and proper person declaration.
Yeah. So Peter, there's a few questions coming up about, there's nowhere to add those fit and proper person requirements to ASQA and all that. And I think that what you're saying basically, if there's nowhere to submit it on ASQAnet, just do it and file it. That's my opinion. We've only got 5 minutes left, so I want to do some really quick sort of fire questions to make sure we get through. But is that right, what I just said?
Yeah. Yes. If you can't use their system, communicate with them in a different way. Email them, call them, right? Engage with your auditor if you need to.
Yeah, so there was a question about, if someone was relieving the CEO for 2 to 4 weeks, I mean, do you complete it and email it to ASQA and say, look, I'm just standing in for 2 to 4 weeks?
Yes. Strictly speaking, you need to submit a declaration because you are the CEO.
They
But
wouldn't appear on Asquanet, you see, though,
yes,
if you're the
but I think that approach of
CEO.
just emailing it is good. I would even do it as a question because they'll never come back to you. That way, I'll even say,
Yeah.
"This is my declaration. Do I need to submit it? I'm only going to be here for a couple of months. Please let me know." And by the time you get a response, you'll be done. Your term will be finished anyway. But
Yeah, exactly. And then there was one just quick question about do heads of vet at a senior school who are using an RTO as that there's a arrangement, do they need, because I mean, obviously if the heads of vet, they are making decisions, but
yes,
the
Yeah, I
RTO,
would say yes, definitely.
yeah,
Yeah.
okay,
100%.
that's what I said
And
as
we apply
well.
higher standards when we're dealing with minors. When we're dealing with school kids,
Yeah.
all the rules go to their max. So yes, absolutely.
Yeah, and then just a quick question. So say like associated persons, third parties, you as consultants, lawyers, could we actually refuse to complete the fit and
Yeah,
proper?
I have. Now, I wouldn't recommend it to everybody, but I have, and
Yeah.
you do it politely, but you most certainly you can. You cannot be forced to sign a statutory declaration, and if they want to have a fight about it, I mean, I've just blankly refused it in one example, and nothing happened because sound minds prevailed inside Asqua, and they didn't. It would have been a complete distraction because what does the fit and proper person declaration of Sally have to do with whether RTO ABC is compliant?
Exactly. And
Yeah.
then just how does ASCO analyze migration agent cross ownership with RTO with FPP declaration? That's because you have to write it on the form, isn't it?
Yeah, but there's no, but the it is what it has questionable. I say it has questionable value.
Yeah.
I question the value of those extensions to the declaration.
Yeah. Okay, I think we sort of broadly got through all the questions. Peter used such a mine of information. I love talking to you. And as compliance nerds, we love all this stuff, don't we? It's so
Yeah, it's a
interesting.
great conversation. I think we could just keep going all day. There's so many questions that could be asked, and it really is at the forefront of everyone's mind because it's something that, is new and it's out there, and everyone, as I said, at the end of the day, everyone wants to do the right thing. So,
Yeah,
and if you're logged into this meeting and in this webinar, you obviously want to do the right thing because you're proactive in your compliance. So, yeah, no, it's great. So it's been a fantastic and insightful discussion, and
We've made it
yeah,
on time, huh?
yeah, that's right.
12:09,
Yeah,
yay.
yeah.
Well
fantastic.
done, team.
I was expecting
It
to go
was,
a lot later than this. So we've done well.
No, it's been great.
We try and keep to time. Thank you
thank,
so, Peter.
thanks for joining us, everyone. That